It is July 17th of 2026, and this is the Court Gallery. Today, we begin in Judge Hesselink's courtroom where a simple retail fraud charge escalates into a potential life sentence when a man's lengthy history comes back to haunt him. Then, we're before Judge Stevens as a family makes a heartfelt plea to keep their loved one out of prison. But his actions and a shocking blood alcohol level tell a very different story. And finally, things explode in Judge Lee's courtroom when a defendant asks to fire his lawyer and then completely loses control, unleashing a tirade of insults and learning a rapid-fire lesson in contempt of court. Ladies and gentlemen, all that and more starts right now.
Good afternoon, sir. Are you Robert Hall?
Yes, Your Honor.
All right. My name is Judge Hesselink. I'm going to call your case and then we'll get started. This is the State of Michigan versus Robert Hall. That's file 26-44729-FY. Mr. Hall, I'm going to arraign you. That means I'm going to tell you what you're charged with, tell you what your rights are, and then we're going to address bond. With me today is Richard Trusch as defense counsel and Amanda Brucker from the prosecutor's office. They're going to assist me in part of this process as well. Listen carefully as I read the complaint to you. It says that on or about July 17th of 2026 in the city of Gaylord and Otsego County that you did commit the following offense known as retail fraud first degree. It says, which reads that you did in a store or its immediate vicinity while Walmart was open to the public steal property of the store that was offered for sale at a price of $1,000 or more contrary to the Michigan compiled laws. That would normally be a felony offense with a penalty of 5 years and or a $10,000 fine. However, the prosecutor has also charged you with being a habitual offender, fourth offense, which says as follows, that you were previously convicted of 3 or more felonies or attempts to commit felonies. In that on or about July 15th of 2014, you were convicted of the offense of delivery or manufacture of a controlled substance less than 50 grams in the 57th Circuit Court for Emmett County in the state of Michigan. And that on or about November 19th, 2008, you were convicted of the offense of possession of a controlled substance less than 25 grams in the 57th Circuit Court for Emmett County in the state of Michigan. And that on or about January 22nd, 2009, you were convicted of the offense of possession of a controlled substance less than 25 grams in the 57th Circuit Court for Emmett County in the state of Michigan. And therefore, the penalty has been enhanced up to maximum of life imprisonment because the underlying offense has a penalty of 5 years or more. In other words, the offense that you're charged with is called retail fraud first degree, and the maximum penalty is now, because of the habitual offender notice, raised to life imprisonment. Do you understand both of those things?
Yes, Your Honor.
As to that charge, you have the right to be tried in front of a judge or a jury. You have the right to be represented by an attorney, and if you cannot afford an attorney, one would be appointed for you. And you have the right to plead guilty, not guilty, or to stand mute. Your trial rights include the right to see, hear, and question the witnesses against you, the right to present your own witnesses and evidence and get a subpoena from the court to require those witnesses to appear and testify. Your right to testify yourself or to choose to remain silent, and that silence would then not be used against you. The right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof remain with the prosecutor at all times. And finally, the right to appeal any error at that trial. However, if you enter a plea in the future, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you understand the rights that I've just given to you?
Yes, Your Honor.
Do you have any questions about any of those rights?
No, Your Honor.
All right. Mr. Trusch, have you had a chance to speak to Mr. Hall about his right to an attorney?
I have. He has been screened and approved for court-appointed counsel.
All right. Mr. Hall, I'm going to send your request for court-appointed counsel to the supervisor of that department, who will determine which specific attorney is going to represent you. In the meantime, I'm going to enter a not guilty plea on your behalf. And then because you're charged with a felony offense, I'm going to set a couple of quick court dates also to protect your rights. The first is called a probable cause conference. That's an opportunity for your attorney and the prosecutor to meet and discuss the case and see if they can resolve it quickly. That'll happen within the next 7 days. The next hearing is called a preliminary examination. That will happen within the next 21 days. That's a hearing in front of me as the district court judge where the prosecutor is required to prove a small amount of evidence called probable cause that you committed the crime that you've been charged with. It is not a determination of guilt or innocence, but a check on the system to see if there's sufficient evidence to proceed. You understand the hearings that we just talked about?
Yes, Your Honor.
All right. What we're going to do now is consider the issue of bond. So I'm going to listen to both of the attorneys as they make recommendations as to that. Once you've heard what they have to say, I'm going to ask you if you have anything else that you want me to be aware of before I decide what to do. Ms. Brucker, your comment on bond.
Your Honor, the allegation is that defendant entered Walmart approximately 15 times over the course of a period of time and stole trading cards and other items totaling around $1,100. Defendant has a pretty lengthy criminal history, including convictions for retail fraud third, retail fraud second, larceny in a building, and various controlled substance related convictions. We would be asking for the court to order that he not re-enter the Walmart store, that he report to community corrections and follow the recommendations, and that he follow the other standard terms and conditions of bond. And we are asking for a $5,000 10% or cash or surety bond.
Thank you. Mr. Trush, your comments?
Thank you, Your Honor. In regards to his history, there is some prior history here, obviously some outlined in the complaint. He reports to me that he does have a couple misdemeanors as well, which is consistent with what the prosecutor reported. None of the offenses that were listed by the prosecutor on the complaint contain any allegations of violence. He has strong connections here to the community. He's lived in Gaylord since 2017. He rents a home here. He participates in the medically assisted treatment program here. So he does have, he participates in the methadone program. He has a job. He is a painter. He's in his busy season right now. He reports, and in the past, he's always appeared for court, and he does have family in the area. He has a daughter at home as well as his fiance and her 2 kids. So when the court considers the 2 factors the court is to consider when setting bond, safety of the community and likelihood of appearance, I think both of those cut in favor of a low bond here. Again, no violent history, no violence alleged in this offense would suggest that danger to the community can be mitigated. And his strong connections to the community, again, suggest that he is a good candidate for a bond. The $5,000 10% bond would seem appropriate given the circumstances. Thank you.
All right, thank you. Mr. Hall, I'm going to ask you in a minute if there's anything that you want to add to that. I'm simply going to caution you not to say anything about the facts of this case because we are recording this and that might be used against you later. But is there anything that you want me to be aware of in addition that relates to bond? If so, this is your opportunity.
No, I would show up for court. That's about it.
All right, thank you, Mr. Hall.
You're very welcome.
This is because of the habitual offender notice, this is a serious charge because it does carry a very high maximum penalty up to life imprisonment. I know that all the attorneys are aware that that doesn't necessarily mean he's going to get life imprisonment, but it is a high likelihood that he's going to get some prison time if he were to be convicted of this. And because of that, I do have to treat this a bit more seriously than as if he were a first offender and this were only a retail fraud charge against him. However, it does appear that the prosecutor's office recommendation is appropriate given not only his lengthy criminal history, but the fact that this is not a violent crime as noted by defense counsel. So I will follow that recommendation and indicate $5,000, 10%, which means, Mr. Hall, that you will need to post $500 before you can be released. The conditions upon your release also include that you appear for any scheduled court dates or all scheduled court dates, that you abide by any judgment of the court, that you not leave the state of Michigan without the permission of the court, that you not commit any crime while on release, and that you immediately notify the court in writing of any change of address or telephone number. Ms. Bruker, is there any evidence in this case that involves the use of alcohol or controlled substances?
No, Your Honor.
Then I will not require any of those in the bond procedure as well. I will follow the recommendation that Mr. Hall not enter into the Gaylord Walmart on the Idlewild Village Parkway in Gaylord, and that he must contact Community Corrections upon his release at the number that's available from the jail, as that is the agency which monitors people that are on felony bond. So you must do that upon your release. Mr. Hall, do you have any questions about anything that the court has ordered today?
No, sir.
Mr. Trush, any questions?
No, Your Honor. Thank you.
All right, that's all for today then. Thank you very much, Mr. Hall.
Thank you, Your Honor.
State of Michigan versus Michael Bryant, file 26-44433-SD, set for a status conference.
Good morning, Your Honor.
This is actually a sentencing. Mr. Horgan and I spoke this morning.
All right, I do see that. And I do see that on June 17th, there was a plea to drunk driving second offense. And I do have a substance abuse assessment. Looks like it just came in this morning and I've not yet had a chance to review it. Ms. Bruker, have you seen that?
I do have a copy of that, yes.
All right, give me just a minute and then we'll move forward. All right, I've had an opportunity to review the substance use evaluation report from the Grace Center and therapist Kristen Wozlowski. Mr. Bryant, I'm going to hear from each of the attorneys as to their recommendations, and then I'm going to give you an opportunity to tell me anything else that you want me to know before I decide what to do. Ms. Bruker, your comments?
Your Honor, defendant was driving down McCoy Road by the roundabout and essentially just drove right into the roundabout. Some of the evidence the law enforcement officer saw was that there were track marks right there, as if he didn't really attempt to even go around it. He kind of just went right through it and crashed his vehicle, which obviously was a pretty dangerous situation given how well traveled that area is. And what have you. He does have the prior OWI from 2021. His blood alcohol results were a 0.155. I did review the substance abuse assessment that indicates he has a high probability of a substance dependence disorder, and they're recommending counseling. I would ask the court to order the mandatory jail time that is required under an OWI second conviction. I'd ask the court to place him on probation so that he can follow the recommendations as set out in the assessment. And I would ask the court to order $245.65 to the Gaylord City Police Department for OWI reimbursement.
Thank you. Mr. Matisse?
Thank you, Your Honor. I've been speaking when I speak with Mr. Bryant, he understands that this is a situation he needs to address clearly. The one thing that was really easy to communicate with him is that he understands that in this situation, especially, he went out to eat, he had some drinks, he wasn't really keeping track, but he did end up at a 0.155. And so he understands that this puts people at risk. He otherwise has a pretty, a well-rounded, understanding demeanor about this. He understands that getting in a car after drinking any alcohol is going to be something that just has to be not an option for the rest of his life. Staying away from alcohol would be great. And he understands that. I think probation would be really important to him, so he gets a period of oversight and gets some substance abuse kind of treatment of some sort. And he has that oversight while he's there. I understand that the previous OWI did not happen that long ago, and likely there's going to be some jail time with it. However, I'd like the court to look at his demeanor with his evaluation, the fact that he's really looking at this and saying, I see the problem. The problem was me and my substance use. And so I'd ask the court to sentence accordingly for that.
Thank you. Mr. Bryant, is there anything that you want me to know?
Yes, I was just wanting to say that I learned never to get into a vehicle after drinking.
Anything else you want me to know?
Well, my health is getting better. I've been going to doctor since last time I talked. Well, just wanted to say that I regret doing my decision on that night. I put a lot of other people at risk, harm. Regret that. That's what I have to live with every day, and it's really gets to me. I take my life seriously and other people's life seriously. I'm here, so I know how people react. It's a job, part-time job. And I keep on continuing on with that and my health.
All right. Thank you, Mr. Bryant. How long were you on probation for your first drunk driving conviction in 21?
6 months.
The criminal history report says 18 months.
Okay, well, I can't remember that far back.
That was 5 years ago.
I'm having trouble remembering right now.
Why did you keep drinking after this incident? Your report from the substance abuse evaluation says that you didn't stop or haven't stopped drinking until June.
Oh, again, it stopped. I was just drinking. And I had urges. It's my fault. I understand what I did. I asked the doctor to put me on medication so it could help me with not drinking.
Okay, but the question was, why did you not stop until June when this incident happened in January?
I don't have a good answer for that because it's my own fault, my decision. But I need help learning stuff. I had her just being honest with her.
I don't doubt that you're being honest with me, but my concern is that you don't understand the depth of the problem. You're thinking that you can fix this problem by simply not getting in a car after you drink. My view is you need to stop drinking. This is your second drunk driving, and you could have very easily killed yourself or somebody else because it's obvious to me that you had no idea that the roundabout was there. That's being so drunk that you have no idea what you're doing when you're driving. That's a guided missile waiting to explode in somebody's life. And you're just darn lucky that it didn't hit anybody.
Right. I understand.
We wouldn't be talking about whether or not you go to counseling or not. We'd be talking about whether or not you go to prison or not. Your blood alcohol level was almost twice the legal limit. Do you understand that?
Yes, Your Honor.
Is there anything else that you want me to know before I decide what to do?
Oh,
I'm going to put you on probation for 1 year simply because I don't think that you've yet figured out that you have to stop drinking. So I'm going to use the probation to keep you from drinking for a longer period of time. There's a $75 crime victim fee, mandatory $50 justice assessment. There's $245.65 in restitution to Gaylord City Police Department for their investigation of this matter. There's $300 in court costs, $200 in fines, and a local charge of $15. There's a $360 probation oversight fee. Let me add those things up for you. It's a total of $1,245.65. You can pay that over probation. You may perform community service in lieu of some of those fines and costs at the discretion of the probation department. You must enroll in and successfully complete an outpatient substance abuse treatment program. and follow all those recommendations. I'm going to require you to go to AA 3 times a week for the first 6 months. There's to be no consumption or possession of alcohol or drugs. No entrance into a business where alcohol is served by the glass. That means no bars, even if they happen to serve food. You may go into a restaurant that happens to serve alcohol. You understand the difference between those two?
Yes, Your Honor.
All right. There will be drug and alcohol testing at the discretion of the probation department. 10 days jail, 10 days forthwith. You are to report to the Otsego County Jail today, 7/17/26 at 6 p.m. Upon completion of jail, you are to do 5 days of work camp within the next 60 days. Do you have any questions about the order of the court, sir? Mr. Bryant, any questions?
Your Honor.
Mr. Matisse, anything?
No, Judge, thank you.
Ms. Brucker?
Your Honor, I don't know if I caught it. Did the court order the reimbursement to the GPD? Okay,
Yes.
thank you.
245.65.
All right.
All right. That's all for today. Good luck to you, sir. All right. I do see Mr. Sweet is with us. Do we have Gabriel Matisse as the attorney for Mr. Sweet?
We
There we
do,
go.
Judge. Gabriel Matisse on behalf of James Sweet. I'd like to let Mr. Sweet know that I've sent his discovery materials over to him at the jail, and the CO will be able to get them to him.
All right. Thank you very much. Let me call the case. This is the State of Michigan versus James Sweet, file 26-44652-EX. This is an extradition matter. We were originally here, I believe, on July the 2nd. It was an arraignment on June 17th, July 2nd. Mr. Sweet asked for a hearing, and so we made the request through the prosecutor's office for the paperwork from Arkansas for that. Ms. Brucker, could you update me as to that?
Your Honor, on June 29th, we spoke to Rachel out of the Van Buren County Prosecutor's Office in Arkansas. She indicated to us that they had completed the governor's warrant process and it was sent to their office. And once they sign off, they would send us the packet if they approve it. So we've not received anything back from from the governor's office yet, but that paperwork has been submitted, we were told.
All right. Are you then asking for a second adjournment for that process to be completed?
Yes, Your Honor.
Mr. Matisse, any objection to that?
Judge, not an objection to an adjournment, but I'd ask that since the governor's warrant isn't there, Mr. Sweet has been asking to see if he can get bond in this matter. I'd ask the court to see if at this point, since we still don't have a warrant, if the court would consider some sort of bond for Mr. Sweet.
What's the reasonable likelihood that he's going to appear if I give him bond?
Mr. Sweet could address that to you himself personally, but Mr. Sweet will participate. He isn't going anywhere. This is something that he has gotten hung up on. I know he's very frustrated with the process because of his previous encounters. However, this is one of those sort of semi-administrative state reciprocity sort of issues. So if the court would see fit, Mr. Sweet would be able to give you his own statement as to why we can trust that he will continue to participate and be here at the hearings, Judge.
Mr. Sweet?
Yes, sir. I live here in Gaylord, Michigan, and I have no reason to leave nor flee from Gaylord, Michigan. So the chances of my appearing at the next hearing would be 100%.
How long have you lived in Gaylord?
I grew up here and I moved away for a long time. I've been back for over 2 years now. My mother has lived here in Gaylord for many, many, many years, and that's where I would be staying.
You've been back for 2 years, but you don't have your own residence?
No, sir.
Why not?
I was in the process of maintaining my own residence when I was arrested in June.
Tell me what that means, process of maintaining your own residence.
I had a good full-time job. I was making $22 an hour, and I was filling out applications for a place in Waters where I was going to move into. Probably would have already been there if this wasn't going on.
Why have you not taken care of this matter in Arkansas?
I just haven't had the opportunity, the money, the time to go travel there. It would cost a lot of money and time. I just haven't worked it out yet.
Is this the second time that you've been picked up on this same warrant from Arkansas?
No, this will be the third time.
No. I'm going to adjourn this for 60 days, let them have their warrant process work. It's in process. I'm sorry, but if you've been told there's a warrant 3 times before and you haven't gone and done it, I'm not going to let you out. The adjournment will be for 60 days. After 60 days, I think I'm required to give you bond, and I will at that point, but I'm not required at this point. We'll be adjourned for 60 days. I'll talk to you as soon as the warrant gets here. That's all for today.
Judge, if we could just please, Mr. Sweet, you should be able to call me. I set up an account for inmates who don't have funds or anything. And if you call me at the number I gave to the COs there, you should be able to get through. So I'm available if you reach out and call me on my number, okay?
Okay.
Yeah, you can get through even if you're totally broke. I set up an account so you guys can do that. So I didn't know you didn't know, but you can call me, okay?
Perfect.
Okay, thank you. Thanks for the time, Judge.
We did the 5-year caps now.
Okay, as soon as I figure out.
Good Lord, Langston, you're on a bunch of these here today, huh?
Yes, sir.
Okay.
Yes, sir. I'm gonna tell you right now.
Yeah, okay, we got Bennett next.
We were in court last in 16, 20
Then,
minutes.
Um,
So check that date.
Then we've got-
pop up.
what are we gonna do on Jasmine Dudley?
She's here. I think that's gonna end up being a hearing.
Well,
Judge,
are we gonna do it today?
Yeah.
Not today, Judge. I'm not prepared. I received the information I needed to file a motion
TRP hearing.
yes, I received it and we filed an amended MTRP yesterday. He filed it and served it on Mr. Adams just yesterday.
What is it alleging that's different?
We added a new offense, Judge.
Hey, do you have a copy of it? So
I have mine.
Where is Mr. Dudley?
I didn't see it.
Is Mr.
No,
Dudley
it's-
in custody?
yes, sir.
or-
She's here.
Oh, it's Jasmine. Oh,
She's here. Look, let me make a copy of that in the back. Let me be here.
I emailed you.
I'm not saying you. I just.
Look, I have a motion filed in January. I don't have,
We e-filed
New.
we e-filed and amended yesterday, Your Honor, when I
can I
received the
see a copy
information.
of it? Real
Yeah,
quick?
yeah, I
Let me just
e-filed as soon as I received the information.
What's the?
commit the offense of assault on a public servant in December of 25.
And then I think
What happened on, well, we didn't, that information, I guess, wasn't received
I just got it
when you
yesterday.
filed that motion in January?
I wasn't the prosecutor in January, Judge, and I just,
That's,
What's
I'm talking to you, I mean, the
State.
the DA's office,
yes, sir.
but,
It's a new offense.
so,
Uh,
okay.
correct.
Has it been filed independently as an individual case in a court or anything else? Has it been indicted or an information been filed on it?
It has been, Judge.
I should just be.
I have a cause number here of 26DCCR 0428.
Okay, so it was filed as a felony, huh?
Yes, sir.
May I
Yes,
see a
sir.
copy
Yes,
of that? Have you seen that?
I know about the 2 cases. I didn't know about the amended info.
Thank you.
I just printed out a copy, Langston.
Thank you.
You each copy.
Filed in March.
When he filed yesterday, I haven't seen the email, so I got to pull it up on my email.
Well, let me clarify. It should have been served, e-served.
Okay.
through
When last night?
Yeah, yesterday.
I haven't boarded it. I'm not saying you didn't send it. I just didn't. Yeah.
Okay, so in this particular case, so far, the amended motion Has not been filed yet.
It's filed yesterday.
Yesterday.
Filed, yes, sir.
Thank you.
Here's a copy for Mr. Adams. We'll get it processed today. It was just filed yesterday, Judge.
Where's my copy?
Well, here, you can take this for right now.
No, I want,
You didn't
I
want
want mine.
I'll get you a
Yours.
copy, Judge, just give me a second.
No, not yours. Hey,
Give me 2 seconds, Judge.
thank you.
10 seconds.
I'm copyless.
Copy.
You know, walking around town like that.
It's
Now,
not,
where's your copy?
good.
I don't
that's
have,
not good.
It's
I
not.
don't have a copy. Well, you're copyless.
Hey, you can't beat that.
That kind of, you know what, that kind of stigma.
Well, thank you.
The,
That's oh, that's original. Give it to him.
Who's on first? Who's on first? Yes.
what's on second?
There we go.
I don't know what's on third.
It's Jasmine Douglas. It's Jasmine Douglas.
And again,
All right.
we just added
On-
the new offense.
All right. Follow the press.
Just to make it clear, the defendant is on probation, correct, for harassment of a public servant, a third-degree felony?
Yes, Your Honor.
And then it's alleged that, number one, she committed the offense of aggravated assault on December 20th, failing to immediately report to probation officer a new arrest, failed to never become intoxicated as being intoxicated on or about December 21st, 2025. Was at a location other than her residence. It says her residence at approximately 10:50 p.m. on or about December 21st. And finally committed the offense of assault public servant on or about December 21st. How many assaults were committed that night?
Well, there was
What-
one assault on the 20th, December the 20th. And my understanding of the allegation is while she was in custody, the following day was when she assaulted the
Oh, okay.
corrections
So
officer.
two separate assaults on two different events.
That's the allegation, Your Honor.
And she's on probation for harassment of a public servant, right?
Yes, yes.
Which was alleged. Did assault, harass, alarm, or cause person known to be a public servant or a Baptist hospital employee to contact the saliva of the defendant? So she spit on someone who is attending her medical care?
An emergency room technician. Your Honor.
Okay.
But Judge, in fairness to her,
I'm just
Right.
looking at what the allegations were here.
she,
We hadn't gotten to the
right,
whether it's true or not, except she did plead guilty to harassment of a public servant and was placed on probation. So I mean, that's a finding, but the others are still to be found. What's her bond on this?
I do not know offhand, Judge.
I mean, these are assaultive offenses and she was on probation for assaultive. Generally, the bonds are high.
Judge, I have here the PC affidavit. Well, let me, no, I don't want to misspeak. Well, I do have the PC affidavit for the most recent allegation, alleged assault of that correctional officer, if the court's interested.
Judge, on the NPRC, her bond is $100,000.
right.
Who posted $100,000? You
Wow.
you got that money?
No, she didn't.
My family helped me.
Okay, so you have access to that. Are you appointed?
Yes,
And you need to be hiring your own lawyer. Well, the taxpayers aren't going to be paying for your legal defense when you can come up with $100,000 bond, man. That's an order. You're going to pay him. He's a great lawyer, but I'm going to make you pay him for what it costs for the people to pay for your representation when you can find $100,000 bond. If you have access to that, you're going to pay for the lawyer fees. Do you understand? That's only fair to the people of Jefferson County. You're not going to pull that.
And then Judge, her bond on the 26 BCCR 0428 is $25,000.
Okay, so you've posted $125,000 in bonds.
So
But just put that in the context.
I did.
Well, no, well, I just want to add something to what's your name again now? Michaela, can you come up real quick? She's a representative of the state of Texas. What Michaela is the CPS worker on a case because when it's not a hearing.
Well, Judge, it's morphing into a hearing here, and I'm not prepared to.
What are you
Okay,
intending to prove here? So get to the bottom so I'll decide whether we're gonna have a hearing. What is that lady here for?
We're mentioning about the bonds, right? And she has a rich history of psychological issues.
She has a rich
right
ability to get money too.
Right. And I also remind the court that Dr. Rapon did evaluate her. He determined that she was competent. However, he did mention about her mental health issues, that she does have mental health issues that she's been treated for.
Okay.
The reason that CPS is that part of when you were setting those bonds, she also, and Mr. Coleman knows this, I'm not surprised him because it's in his discovery. In the discovery that was provided by the state, they mentioned a CPS case, and that's in their discovery. Yeah, it is. It's mentioned. But here's where I'm going with it.
Where are you going?
So here's where I'm going with it.
Okay.
Yes, it's in that discovery. So I'm not telling him something he don't know. CPS was in favor of her having a bond to be able to get to her kid because as it was going through the case down there.
That's okay.
Right.
But it's still, I'm sorry, but it wasn't their decision. It was mine. I made the decision.
But
I want to hear as much input as possible and make a fair disposition. So, but what does that have to do with anything else?
Well, here's the point that I'm making.
Yeah.
When the court was talking about $100,000 and $125,000 bond, part of that is that CPS wanted her out on this case so she can get back to taking care of her child.
Okay.
And what happened?
I made the final decision.
No, you did.
Okay.
But what I'm saying is that she had to hustle and gather resources, and that's why Michaela can tell you that.
So hey, everybody,
and she's here to say that.
But she's got. Well, that's fine. But she has resources.
Yeah,
a lot of
that's the state's position as well, Judge. If she can marshal the resources to make the bond, the state's position is she can marshal the resources to pay for an attorney.
Yeah, I'm going to order that ultimately because she has resources and the people are going to pay. You get entitled to be paid because you're a fine lawyer and you do a good job. But the people are not stuck with the tab when the defendants have the ability to get resources. And as far as her other situation that you were talking about, okay, she's imperfect.
Mm-hmm.
Big deal. We all are. Each of us here have issues of imperfection, and some people's phones go off in the middle of the when they shouldn't. They.
But you're right.
But welcome to planet Earth. But you just look at the imperfections and do the best you can and make the best choices you can. That's what we do. And I wish I didn't make a mistake today. And we all make mistakes. And some of us and all of us have inabilities, whether it's I've got to wear contact lens. I don't have perfect eyesight. Everybody is born with Achilles heels.
Right.
And deal with them.
Right.
And we all deal with them and we do the best we can with what we have to work with. Because our creator gave us enough to work with to get the job done. And it's a test we all go through in making decisions and achievements through our life, in spite of the fact we're imperfect. You're in that boat. There is no reason, I've looked at this, there's no reason why you should be making bad choices. Fix it. If you make a bad choice, fix it somehow. Fix it and don't do that again. That's, and I'm sure that you have children.
Yes, sir.
I bet you told them that.
Yes.
Or where's the, yeah. Don't do that again. And then that's what a form of discipline as a parent to a child, because they go, okay, now I know what the right thing to do. We learn, and we learn through our whole life. Even adults make mistakes. The older adults, and when we make a mistake, we fix it as soon as possible and correct it and do better. Don't do it again. But that's what probation is all about, and we're very excited about the performance that the probation has, because I want 100%. We're at 93. We have a 93% success rate on probation. The national average is 75. What does that say? These people are doing their job. They're great in doing their job. I had to tell a bunch of folks about it last night, and about how good and proud this county is with our probation office, because people, that's 13 out of 14 people do great. 13 out of 14. There's no reason you shouldn't be 13 out of 14, except we're all held to the choices we make. You make a bad choice, you can be punished for it. You make a good choice, you're rewarded. It's simple. And here we put you on probation a while back, and it's alleged that you're doing similar things. I don't know why that's happening. It needs to get fixed one way or the other, but your choices here were not well made according to these allegations.
Right.
And why you made poor choices, knowing that it has consequences to it, is what we're trying to get to the bottom of. Because I don't like failure. I wish it was 100%. I really do.
Right, and Judge, and that was another reason why I had CPS here, is that I anticipated, and my understanding from talking with CPS, that the state of Texas, by way of CPS, was going to advocate for her to continue to be on supervision. And the reason why is how well she did in her service plan with her kids. She's actively involved in the kids, and that's why
I hadn't heard anything.
She's here.
If
She's
we're
here
gonna,
for.
I'm not
we haven't
prepared.
hearing it.
I'm not prepared to go forward with the hearing, Judge.
Yeah,
No.
let's.
I'm just saying what I anticipated that she would have said.
Okay,
if we'd have
but
had
what all that's, I'm anxious to hear it, but she's on probation for harassment of a public servant. She is charged now with assault on a public servant.
Yes, sir.
That's good luck on convince me about that. I don't know what it is, but that's kind of odd. And those allegations are disturbing when if she's charged with similar conduct for which she was charged with before, for which she was disciplined for before, and for which she stated under oath that she would not do again. So that's going to be interesting. But hey, she's presumed innocent. I wrote that article. I'm pretty proud of that. But all of that being said, let's move on. Number one, again, she has access to monies. Those are going to go toward the payment of the people's servant that Mr. Adams is in representing you. If you're able to pay $125,000 of a bond, you're certainly going to be able to pay your public defender here, and that's going to be ordered. He gives us a bill at the end. When do we have a hearing?
Same date, if you don't mind, 3 weeks out, because I got that other guy that you
Good
said
for everybody?
3 weeks out.
Yes.
Done.
Same date.
That's it. Thank you.
Thank you. I give Richard.
Mr. Bennett?
He already signed.
Okay, Bennett, come on up. That's Philip. Does he need to sign?
He's already signed.
Okay.
He signed, Judge, and Ms. Simon sent it back to me, and I'll send it back to you.
Oh, that's what we call
Yes.
signing back. I like that. We now call cause number 24 CR 303, the state of Texas versus Philip Bennett. Is it Bennett or Bennett? Bennett. And you were here with Mr. Adams, your attorney, and the state's attorney.
Yes, sir.
What we have here is a motion to revoke probation. Is this the one filed on October 30 of last year?
Yes, sir.
Is that right? Yeah, that's locked. Everybody, is that right? He says yes. Was that right, Langston?
Yes, sir.
And stay.
Yes, you.
Okay, good.
Right here.
All right.
October 30th.
I didn't know if there was another one coming through the pike or anything.
No, sir.
All right, in 24 CR 303, the state of Texas versus Philip Lawrence Bennett. Sir, raise your right hand. Do you solemnly swear or affirm any statements you make during this motion to revoke probation hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your hand. Does the defendant waive a formal reading of this motion to revoke unadjudicated probation? Can we proceed in summary, Mr. Allen?
Yes, sir.
In summary, this motion, which was filed October 30th of 2025, in summary, it states that on August 27th, 2024, in this criminal district court of Jefferson County, Texas, you were placed on 10 years deferred or unadjudicated probation for the third degree felony of deadly conduct by discharging a firearm. Is all of that true and correct, sir?
Yes, sir.
Allegation 1 states you committed the offense of driving while intoxicated, I guess operating a motor vehicle while intoxicated, a DWI,
Yes, sir.
on or about October 4th, 2025 in Jefferson County, Texas, which was a violation of condition 1 of your probation order, which states commit no offense against the laws of this state or any other state. Is that allegation true or correct, sir?
Yes, sir.
Are you pleading true and correct to that voluntarily and because it is true as it is alleged?
Yes, Your Honor.
Do you understand that a voluntarily and knowingly made plea of true to one or more violations, that's enough to grant a motion to revoke probation? Your probation can now be revoked. You can be found guilty and you can be sentenced to no less than 2 nor more than 10 years confinement in prison under this third degree felony. Knowing that, do you insist on pleading true to that?
Yes, Your Honor.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true. Let's see, I'm looking at number 2 is failed to never become intoxicated. Do we really need that one? We've got the DWI on 1.
State's willing to abandon that, Your Honor.
3, failing to provide verification performing community service hours.
I'd like to leave that one in, please, Your Honor.
All right, number 3 states you failed to provide verification of performing community service hours. And according to the administrative hearing filed by the probation office to support the filing of this motion, it states that you were assigned 600 community service hours. You completed 276 and have 324 remaining. Let me ask on probation. Was he doing okay on community service hours? He didn't complete them, but he was only on probation for a year.
Yeah, he was always almost at his halfway mark, Your Honor.
Okay. Well, okay, he was at his halfway mark on what?
Community service hours.
Okay, and he was on probation for 10 years, but he had only been on probation for a year, right?
That's right.
So he was about 10% of his probation time, but he had served half, he had covered half of his, that's pretty good, isn't it?
Yes, Your Honor.
Okay, I'm not gonna punish him for that. It sounds like he was trying. We're gonna be okay on that one. Can we abandon that?
Judge, if the court's inclined to find it not
Well,
true, then I
yeah,
don't
because-
necessarily want to abandon it, Judge.
But where was he on? I mean, was he didn't complete it, but was he caught up?
He was almost caught up. Yes, sir.
Well, I'm not gonna punish it.
But if the court's inclined to find it not true, then that's fine, Judge.
All right. Number 4.
We'd like to keep number 4 and abandon number 5 with
Okay.
regard to the fees, Judge.
4 states you were at a location other than your residence at approximately, it says 23:49. That's military time. I presume that's 11:49 p.m. on or about October 4th, 2025, in violation of condition 18 of your probation order and 18 of your probation order states that you must be inside your home every day between 10 p.m. and 6 a.m. except for employment purposes. So that was about 2 hours outside your curfew. Is that true?
Yes, sir.
Are you pleading true to that one that violation true because it is true as it is alleged?
Yes, Your Honor.
And I've already told you that unknowingly and voluntarily made plea of true to one or more violations, that would be enough to grant a motion to revoke probation. And your probation could be revoked. Do you understand?
Yes, sir.
No. And we're abandoning 5.
Yeah, Your Honor, with regard to the fees. The state has a brief argument.
Hold on,
We don't have witnesses.
we've got a second case.
We get to argue. Huh?
We've got a second case to deal with
I
too.
think they've got the same mirror allegations, Judge.
Mm-hmm.
Well, we got to pick them up.
Okay.
So 24 CR 304 is called the State of Texas versus Philip Lawrence Bennett, who is the defendant. And in this case, there's a motion to revoke probation filed as well as of October 30th of 2025. Does the defendant waive a formal reading of this motion? Can we proceed in summary?
Yes.
All right. And again, you're still under oath in this hearing, so remember that. All right. In summary, this motion to revoke unadjudicated probation states that on August 27th, 2024, 2024, in this criminal district court of Jefferson County, Texas, you were placed on 10 years deferred or unadjudicated probation, as well as in the previous case for the 304 case of deadly conduct discharging a firearm, a third-degree felony. Is that true?
Yes, sir.
And
State abandons allegation number 2, Judge.
allegations 1 and 4 are the same as what you have pleaded true to in the previous case, committing the offense of driving while intoxicated on or about October 4th, 2025 in Jefferson County, Texas, and 4 at a location other than your residence at approximately 11:49 p.m. on or about October 4th, 2023. And those are violations of conditions 1 and 18, respectively, of your deferred or unadjudicated probation order. Are those allegations true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to those?
Yes, sir.
Voluntarily and because they are true as they are alleged?
Yes, sir.
And again, you are understanding that a true and correct violation of one or more violations of probation, that is enough to grant a motion to revoke probation. Your probation can be revoked and you can be sentenced up to the full range of punishment. In this case, it's the same as the previous case in the motion to revoke probation. You were looking at no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Knowing all of that, do you insist on pleading true to allegations 1 and 4 in this cause number 24 CR 304 in this motion to revoke probation, as well as the previous one?
Yes, sir.
I find you are pleading true, voluntarily, knowingly, intelligently, and there is enough to grant these motions to revoke probation, enough evidence by a preponderance of the evidence or greater to support the motions to revoke probation. What are we going to do?
Judge, it's a cap of 5, and I got 2 witnesses I want to call.
And go ahead.
All right, I want to call a probation officer as the first witness. All right. All right. Did you have a-
Hold on. And raise your right hand, sir. Do you probation? But I like your vigor in raising your right hand. You solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth. So help you God. So lower your hand and go ahead.
Will you state your full name for the record?
Jesus Ruiz.
And Mr. Ruiz, you were the probation officer in this case?
No,
Okay, who you covering for?
Joseph Champ.
All right, so you're covering for Mr. Champ. That's fair. That's no problem.
Oh,
So-
hold on. Are you familiar though with these files to be able to speak intelligently about what's in them?
Somewhat familiar, yes.
All right.
So basically what Judge said, you had a chance to review all of the notes of Mr. Champ and everything that he's done in this case.
Yes.
All right. And in doing so and reviewing Mr. Champ's notes, you understand that my client was placed on probation on the 27th day of, well, he was placed on probation specifically. This order was entered on 10/30 of 2025. That's the date that I see this file stamp. All right. All right. And let's deal with one of the allegations that was abandoned. And I think that that's positive for my client. You understand the judge pointed out that in terms of his community service, he's placed on probation for 10 years, right?
I want to be clear, the state didn't abandon that allegation.
Yes, you did.
No, I did not abandon the allegation about the community
Okay.
service. I welcome the court to find it not true if he was so inclined, but I didn't abandon.
Okay, well, the bottom line is that would you, in terms of failure to provide verification to community service office, you do know that he's done over 50% of his community service?
Not 50%.
How much has he done?
276 hours.
Out of how many?
600. 50% will be 300 hours.
Okay, so he's pretty close.
Pretty close.
So as it relates to providing verification, you do know that he did do the 200 and what?
76.
And do you consider that doing pretty well?
It's pretty well.
That's pretty well. And is that better than most people who's on probation?
I'm not sure.
What are people who you supervise?
They tend to meet the halfway mark.
Okay.
And 93% are successful.
All right. The next point that I want to make to you is that in addition to doing his community service on his arrears, I noticed that these arrears are just $308. Is that right?
Yes.
Right. So he has been making payments while he's been on probation. Is it right?
Has been making some payments. That's it.
Well, not just some. I mean, at least according to what I got here, total credit 1,112 is what I read right here for the total credit as payments.
Yes.
Right. So he's not just making some payments. He made at least 1,112. I mean, so he's making payments, right?
Yes.
And I see that he's periodically making $60 payments, $155, $115, $105, $85. So he's making regular payments.
Yes.
Right. And that only left him with arrears of 308, right?
Yes.
Right. And in doing these cases, I've seen people that's $1,000 in arrears, right?
Yes.
So as another positive about my client, he's making payments and he's also ahead of the game in his community service. That's a positive, right?
I don't know about ahead of the game, but he's on his way. Yes.
Okay. Also, as it relates to the nature of the offense that the state is going on for this October the 4th, you did get a chance to look at Mr. Champ's notes and administrative hearing. In terms of this DWI, this is not a DWI when we got an accident, somebody's injured, a DWI where somebody is a danger to the road. This is one where he is in a parking lot parked and the underlying, and you can look at it if you don't, just refresh your under findings. They had administrative hearing and he's basically, have you seen this?
Yes.
Yeah, he's basically in a parking lot parked, right?
Mm-hmm.
So he's not driving a car at that time. Is that right?
No.
Right. And so in terms of the seriousness of this particular offense, this isn't a DWI where you got a wreck, somebody injured, he's on the road, he's in the parking lot sleeping. Is that right?
Yes.
Now, the judge has mentioned about the success rate of the probation department in terms of programs that you can provide for him that he's admitted to on the driving while intoxication on October the 4th. What programs does this probation office provide for people who have some alcohol problems? Do you have any programs?
And we have substance abuse assessments that we provide. We do have programs. Yes, sir.
And at the time of this offense, was he getting any of those substance abuse treatment?
I am not sure.
Okay. And if he's continued on probation by our judge today, could the judge order him to take the substance abuse treatment while keeping him on probation?
That's his decision.
Actually, could he do so? And the answer would be yes, he could, right? All right. Now, how do you feel about that substance abuse treatment program? Do you think it's a pretty good program?
It is a pretty good program.
How well is it? How would you describe it?
With my clients, they've had pretty good success.
All right. So do you have any reason to believe that if he's continued on supervision and he's put into this program that he would not be successful?
I'm not sure.
All right. But you
I don't know the client well enough.
I got you.
Make that decision.
But in going through the notes of Mr. Champ, you don't see nothing that would say he wouldn't be successful, would you?
No.
All right. So in addition to the programs that you provide in your department, which is the substance abuse, how about in the community as a whole, Jefferson County? Do we have programs here to help people with alcohol, like AA, right? So now, in addition to the programs that he would have access to through your department, which is in the community as a whole, we would also have access to those programs, right?
Yes.
So if the judge with this 5-year cap offer continues him on supervision, he could be in those programs and not be a danger to anybody in the community. Is that right?
I don't know about that. I could be in the program and still be a danger.
Well, you could be a danger to somebody today.
That's argumentative.
No, well, that's
State objects. That's argumentative.
Sustained.
Well, at the end of the day, anyone can be a danger at any particular time. Do you understand that?
Yes.
All right. So in his particular case, if he has the program that you just bragged about, if he has the access in the community and he's doing what he's supposed to do, he can probably continue to be on probation and be successful. Do you understand that?
Yes.
All right. And the probation department can meet all of his needs that need to be met. Is that right?
Yeah.
By continuing him on supervision. All right. Last question for you, and here's where I'll stop. I know you said that you were not the supervising officer, but in reviewing Mr. Champ's notes, from reading his notes, what are the positive things you can say about my client? From your reading of all of his notes.
He was somewhat compliant with his probation. He was going to office visits. He was doing pretty good on his community service, and he was meeting his payments.
Okay. And did Mr. Champ express any feelings to you about this particular case? So when you covered for him, you basically took the file, but you didn't talk to him about as to what Mr. Champ's recommendations were, right?
No.
All right. So you're not prepared to give a recommendation today. That's more for Mr. Champ.
Well, he's retired. So,
well, he's retired. Well, he can't now, but I'm saying he's not here
yes,
to give a recommendation because he's the main one, right? And what you say that you can't do it because you're not the one who supervised. All right, pass the witness. Thank you for your time.
As I may, Your Honor, I'd like to direct your attention to the administrative hearing and the report or the document from that hearing dated October the 6th of 2025, particularly the findings. And if you need to, just take a quick look at it to refresh your memory of that or recollection. Oh, and just tell me when you're ready.
all right.
All right. Particularly with regard to these highlighted portions of the findings, when the officer or officers encountered the defendant with regard to the DWI arrest, where was he located?
He was in the middle of the parking lot.
At where?
At Taco Bell.
And did other vehicles have to go around him?
Yes.
And it was indicated that when law enforcement made contact with the defendant, what state or condition was he in?
He had thick saliva running out the side of his mouth.
And eventually, the officers, how did they get the defendant to awaken or respond?
They had to be on the driver's side of the vehicle.
Okay. That's all. I passed the witness.
So basically, in what you said, I mean, people don't speed in parking lots, right? I mean, you shouldn't be, shouldn't you? You shouldn't be. All right. So in terms of what he's in the middle of a parking lot and the saliva that comes out of mouth, I mean, the common term for that is drooling. I mean, that's associated with sleeping. You understand that, right? And at the end of the day, he's parked in a parking lot sleeping, and in that parking lot in Taco Bell, people drove around so they can get into the line to order their food. All right. So for purposes of continuing him on probation and how this question is relevant for the judge and continuing him on probation, out of all the kinds of DWIs you can have, this is not the most serious one. You don't have him drunk and killing somebody, drunk and getting into a wreck, drunk and hurting himself, drunk or hurting somebody else. He's sleeping in a parking lot. Is that right?
Yes.
Right. So, and that would be one of the arguments and basis for continuing on probation as it relates to the seriousness of the offense. Pass the witness and
just one follow-up question, Judge. Based on your experience, your life experience, how do you surmise that this defendant got to that parking lot there at Taco Bell?
the rejection speculate his life experience is irrelevant to the question. It's told whatever his life experience is not a relevant question for this case. His life experience is not material to this case.
Your Honor, the court can draw an inference. I'll move on.
Go ahead.
That's all I got, Judge. I got another witness. That's it.
All right. Let me ask a question here. I'm looking at all the papers. agreed punishment recommendation here, a cap of 5 years.
Made by the previous prosecutor, Judge.
It says the sentence will run concurrently with the DWI. What DWI are we talking about?
The underlying offense.
I think it's in Judge Holmes, if I'm not mistaken. And he's gonna handle that too and try to dispose of everything.
That's the underlying offense, the Taco Bell incident we're talking about.
Okay.
Right. I believe
So
that's
there's not an agreement that this, each of these would run concurrent, each of these motions.
They're gonna run together.
That's not what this says. It says will not
it should
exceed a
be.
cap.
I'm
Look
sorry.
what it says.
No, I believe
See,
you.
it doesn't, it just says the DWI. It doesn't say concurrently with the other.
I can add that. It was.
Is that the plan,
Yeah,
though?
that was the plan.
While I didn't negotiate it, Judge, I can understand that would be the
Okay.
intent of the parties.
Right.
Okay.
Right.
You want me to add that?
Yes, sir.
Well,
No objection, Judge.
okay. This is 303. So what I'll do is we'll run concurrently with DWI and 24 CR 304. Good.
And that's
And
it.
what we'll do on the other, the agreement, it will run concurrent. The 304 case will run concurrently with 303 on the other one. We'll make a change on the other one as well. Langston, okay?
Yes, sir.
Go ahead. Y'all go.
Edward Boltwine is his grandmother.
Come on.
I don't have any more questions for you.
No, she's going to come up. He's going to have to see the bailiff. No, the bailiff makes the decision if when they're in custody. It's a. He can sit right there though. He'll be present, or he can sit in the witness chair.
Well,
I don't care.
I don't even point. That's something new. I mean,
We don't.
do that.
Yeah, it's up to the bailiff's decision. I mean,
I don't know how that affects any substantive right of the defendant, Judge.
it doesn't.
Okay.
He's present.
Yes.
He's present. That's what's important. He's present. They don't have to stand next to each other for the law to apply. Go ahead. Call your witness. What's your
Can
name?
you state your full name for the record?
All right. Raise your right hand, man. Do you solemnly swear or affirm the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth? So help you God. Correct? Okay. Lower your hand. Thank you. Go ahead.
All right. Mr. Bennett, my client, how do you know him? All right. And were you with him when he got first put on probation? Were you helping him?
Yes, sir.
All right. And do you understand that today is a motion to revoke his probation and the judge could put him in prison up to 5 years and keep him on probation? Do you understand that? And as his grandmother, you're here today to talk about how well he was doing while he was on probation, right? Could you tell us some of the good stuff that he was doing while he was on probation?
So whenever I leave in this
Uh-huh.
it's always
I can't. Well, speak up what you need.
whenever I needed him to help me around the house, he was always there present. And he helped me pretty well. And he always was obedient for him.
Yes, ma'am. So how did he help you? Do you depend on him?
Well, yeah, it would depend on him, like when I needed lights changed on the flood lights.
Mm-hmm.
He was there. He kept me going.
Mm-hmm.
He just did it.
So basically, the heart of why you're here is you're here to testify to why would you want the court to continue him on supervision, right? And not send him to prison.
Yes.
So can you tell the judge in your own words, why would you ask the judge to keep him on probation?
Because we're not really there at all.
Mm-hmm.
He's so deep. We have a kind of heart.
Mm-hmm.
And we like to work.
And if he's on probation,
Take care of the son, his 3-year-old son.
Now you heard the probation officer talk about what kind of great substance abuse program that they have. If judge keeps him on probation, would you help him with transportation and getting the substance abuse treatment that the probation officer just talked about?
I don't drive no more, but I can get someone to bring.
You better get somebody to bring him. And who's the lady in the blue?
That's his mom.
That's his mother. So his mother has transportation, right? And the mother still got you to court today, right? And do you know whether or not she'll be willing to get him transported to where he needs to go on probation?
Yes.
And apparently he's been doing pretty good because he's been paying his fees. He's been reporting, at least from what they're saying. He's doing well with his community service, right? So all of those are positives and would be indicators that if he is continued on supervision, he's going to do well. There's no need, right? Right. And another argument, and I'm asking you as a question, would you agree with me? Did you hear the court, mention with the other lady about, having the taxpayers' money and spending taxpayers' dollars? Wouldn't it be better to continue him on probation with the support of his family and the support that he has around him than to have our tax dollars locking him up in prison where he's not going to get that support, right? Okay. And he's not, and in your opinion, do you believe that he's going to be a danger to himself or anybody else, or he's not going to be a danger? And even in this underlying case, he was in the car basically sleeping, right? Mm-hmm. And with those other resources, AA and all the other resources that Jefferson County has, would you and the mom make sure that he gets that treatment and those things? Yes. All right. So at the end of the day, and here's where I stop. Do you want your grandson to be continued on supervision? To continue to be on probation, that's what I mean. Yes. That's all I got. Thank you for your time.
I have no questions for this witness, Judge.
All right, anything else?
I think that's it.
From anybody?
Anybody?
Okay.
Huh?
All right. She can be seated and the defendant needs to come up.
Well,
are you calling somebody else?
Just that'd be 30 seconds. Come on up, man.
I'm just waiting.
And I'm just gonna ask her one question. What would she like to tell you? And that's it. And that's his mom. I'm just gonna ask one question, and you can tell the judge whatever you like.
Well, Judge, I would have kind of objected to the narrative.
Hold on. Identify.
All right, would you state your name?
Yes, my name is Defendant.
And how are you related?
I'm his mother.
Raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Yeah, it depends on where it was. Let him ask if you want to make an objection.
Well, Judge, in response to him, a narrative of response is not necessarily objection.
You just ask the question and we'll play from there.
All right. What did you want to tell the court?
Yes, sir. I'd like to let you know that I do have a job. Make a lot of money.
I'm talking about him.
Of money. Yes, sir.
Yeah. And how's that relate to him?
Yes, sir. And it's my son. And I have a little money I give to him. He wanted to be a man, so he cut grass to pay his fees. So when he was paying $80, he wasn't just sitting in the house. It was very hard for him to get a job as a felon.
Yeah.
So he did cut grass. He did what he could to pay. And when he started his job, he had to do training. So he got to build back a little bit on his community service, trying to work and provide for his son. He has a son with special needs right now. Just found out.
I'm sorry, he was
special needs.
He has a son with the special needs. He's autistic. And
well, wait. Where does that son live?
That son lives with me and his mother. While the mother worked, we have the baby.
No. Okay. When he wasn't in jail, where was he?
He was
with the child.
He was taking care of his son while the mother worked. And between his work, yes, sir.
Okay.
And he also took care of my mother.
Hold on. Well, let me ask you, not to interrupt you, but who's taking care of that child at midnight when he's drunk and intoxicated and inebriated at a location and completely unconscious? Who's supposed to be taking care of this child that we're so concerned about, that he's supposed to be loving and caring for, like me as a parent, because I've got 2 children.
The mother. He had just got.
Well, where's the mother?
The mother, she's
at the time.
They don't live.
She was at work. Wait a second. He's intoxicated and wiped out at the drive-through, and the mother is working. What's the child doing by itself?
No, the mother wasn't working. He had gotten off.
You said she was.
The mother had the baby. The mother was at home. He had gotten off from work. He was at work that night, and he had gotten.
Why wasn't he at home taking? It takes. I'm a parent. It takes 2 to run the household. Why isn't he at home at midnight when he's supposed to be just as a good parent? But not only that, he's ordered to be at home. What is it, at 8 p.m.? He's ordered to be. He was 4 hours late. He's intoxicated and unconscious in the public while the family is at home. That's not good parenting, is it?
They don't live together, sir. He lives with me.
Okay. All right. Why is he somewhere else other than at his home where he's supposed to be as the court ordered? I know you can't. It's not fair for you. I understand.
He takes good care of my mother. He takes her to the doctor.
He can't do it when he's intoxicated and unconscious at midnight out in the public, can he? No. You got responsibilities, sir. My God. Those are special. Our Creator gives us our children, and you're supposed to take care of the gifts that are being given to you. And you're unconscious on my watch on probation when you know better. Reminding you, you're on probation not for just something, not from just spitting on the sidewalk. You shot out shot at a car, and shot at buildings. I mean, all kinds of trouble was happening there. Many could have died. So you had to be, when we placed you on probation, which was a close call on a charge of what's called deadly conduct, that's a very serious crime. I stuck my neck out and allowed this probation. And I was hoping you would, like I hope all of them, do well on probation. 13 out of 14 are successful. I didn't want you to fail. Nobody wants you to fail, but these are your choices, not everybody wants you to do well. But you've got to do the lifting. You've got to do the heavy lifting like each of us do each day. We're responsible for our actions. And you pay when you are irresponsible. And I'm telling you, this is irresponsible behavior at midnight when you're supposed to be at home, when you're on probation for 2 deadly conducts. You're supposed to be taking care of family. But for some reason, you're out, wiped out, intoxicated in the middle of the parking lot and at midnight. You're supposed to be at home, sober. I'm railed on enough.
Well, on that issue, was this something out of the ordinary, or this is something that happens all the time?
Out of the ordinary.
Right. So on the point of him being in the parking lot on that particular day, are you saying that that's something that's just out of his character?
Completely out of his character.
And what would substantiate your position is that let's look at what he was doing on probation. He's paying his money, he's reporting, he's ahead of the game on community service, right?
Yes, sir.
He's being complimented by the judge on what he's doing with his community service, right?
Yes, sir.
So at the end of the day, if we compare his actions while on probation to this one particular day, then this one particular day is out of the ordinary. Is that right?
Yes.
And would you say that the chances of another day like that happening again is not really good? Is that right?
Not really good. He wouldn't do it.
Right. And probation department just talked about their programs and how good the programs are. And if the judge puts him on those programs, you got the transportation. I think that's why you told the judge that you got the transportation. You will get him to the places that he needs to go, considering that this was an out of the ordinary situation.
Yes, sir.
Is that right?
Yes, sir.
Thank you for your time.
I have no questions for this witness, Judge.
And let me just correct for the record on the math part. This was his second bad day. His first bad day, we put him on probation for.
You come this way, my man. I got you. I'm not arguing with
You can only do the best you can. All right.
Did you want to hear from him?
It's up to y'all.
Did you want to touch that? Yes, ma'am. All right. One question for you. You know that judge can put you in jail for up to 5 years.
How much time credit?
Put it up there.
Thank you.
The judge can put you in jail up to 5 years based upon the plea deal that we got with the state of Texas, or he can continue you on supervision. Speak on your own behalf now and tell the judge why we're asking to be continued on probation. You tell him.
Yes, sir. I really just was trying to make it back home to make sure I could take care of my grandma and my child as well. I mean, I was doing everything I was supposed to do. I was taking care of all of my fees and doing my community service, but like my mom wanted to previously said, I just wound up starting the job and I started putting more time into it. And I also have messages between me and my manager. Me and my manager would always talk. I was just putting a lot of time just trying to learn stuff, but I was going to become a manager. So I'd be making more money to provide for my family. And I wound up going through a little depression. And I also got the records from Spindletop. I could get those too as well. I just wound up going through a depression dealing with my first case. So
What do you mean? Depression for your first case? I mean, you intentionally committed those acts. What's the, I mean, what are you mad at yourself? You intentionally committed those acts. That's what you pleaded guilty to. What are you in depression for? You acted with intent to do that. So it's not like it was an accident or you were forced to by someone without your free will.
Yes, sir.
Don't be blaming something when it's your intent. You've got to stand up like a man, and actually that's what you did when you accepted responsibility the first time.
Yes, sir.
Because this was serious.
And you heard about from the probation officer when he testified about programs that are available to you. Did you hear his testimony, right?
Yes, sir.
And I asked him, think the program was pretty good. He said, yes, it is.
Yes, sir.
That came from them, right? So if they have a pretty good program and he says that it's a pretty good program, your mama saying that she's going to do the transportation to get you there. The question I got for you is, if the judge keeps you on probation, will you do the program?
Yes, sir.
And will you be there and listen attentively and do what you need to do?
Yes, sir.
All right. So are you asking the court to continue you on supervision based upon what the court has heard from the probation officer, yourself, your mother, as well as your grandmother?
Yes, sir.
All right. And this time, if you got this one shot, you're not going to let any others down, are you?
No, sir.
All right. Thank you for your time.
I have no question for this defendant, Judge.
Don't go anywhere. Anything else?
That's it, Judge. I just would ask the court to continue him on supervision, and I'm not going to rehash everything that you've already heard.
I'm sorry, please.
I'm not going to rehash everything that you've already heard. Is just listening to the mom, the grandmother. I really believe that they're sincere from their heart.
Hey, let me ask something before we finish up here on evidence in this case. I'm looking at
yes, sir.
This report on this event at 11:30, almost midnight here on October 4th. And it states a requested Philip's blood, according to the policeman. Requested his blood. He consented. He also signed a DIC 24. I transported him to the county jail, checked the blood draw, ensured it was not tampered. It was not tampered. Draw was made at a little after midnight, about 1 o'clock, and he was released. I placed the blood evidence in the blood evidence fridge. There's nothing in here that talks about what
we got the test back.
I don't have anything about the result.
If there's no objection from Mr. Adams, Judge, I tender to the court.
It came back.
I tended to the court the lab report indicating a 0.197 BAC from that evening.
Okay. Well, that's 2.5 times the legal limit. Ethanol. So you were 2.5 times the legal limit at midnight when your family was at home and you should have been at home, right?
Yes.
Okay. Give it your best shot.
Judge, like I said, you heard all of the testimony. I do believe, and I'm not going to rehash everything that you've heard, but I will give my commentary on that. I do believe that the grandmother, I do believe his mother is absolutely sincere, and they appear to be.
I'm sure she is.
And I don't know them personally, but just from my judgment of character, they really truly love their grandson, and I really believe that they're going to be there to help him do well on probation.
But they were there before.
Right. And as they testified that was an out of ordinary situation with the probation saying that the treatment program, the substance treatment program is so good. I don't have any doubt that they're going to make sure he gets there. And I don't have any doubt that he's going to actually go there and get the treatment that he needs. And I think that Judge, if just from what I can tell about him, and that's just my position and argument, he doesn't appear to be one of those type of guys that needs to be incarcerated in prison. That's going to be a danger. That's going to be acting a fool. And I understand what the underlying offense. I get you.
What about that?
No, I hate that.
Have you ever done such a thing? I haven't. I wouldn't even thought about shooting at cars and buildings.
Right.
At people where people can be shot and killed. Come on. That's
no.
He was, you represented him on the underlying case, right?
Yes, sir.
Yeah. You did a fabulous job on giving him a second chance in light of the potential catastrophe that could have occurred because there were numerous bullets shot. Yeah, that was a remarkable defense of getting him deferred or unadjudicated probation. And that's why, and you made promises to me, I'm going to follow these rules. And I stuck my neck out and gave you that chance.
And in terms of following those rules, Judge, I would ask to give him some consideration just on what the probation department said. In following those rules, he reported, was doing that community service.
He's not getting punished for what he did do.
No.
Properly.
But he's
going to get punished for what he failed to do as required.
Right. But I would just ask that the court would take that in consideration for mitigation purposes, because those were the things that he did well. And your probation department brought those things out. And the point that I'm making, Judge, is that I totally feel you on the underlying offense, but just look at it. I mean, he doesn't seem to me as that type of guy that
he's been in jail.
Well,
they don't let him have handguns in jail, and they don't let him drink.
No.
I mean, he's. But that's the problem is when he's in the free world, we have a problem keeping him from making mistakes and not following the rules. That's where you're not getting punished for good behavior. You're punished for failing to conform to what you were required to do, that you promised you would do. Follow all the rules.
I just think, Judge, if you give him this one shot, and I know you gave him first shot, which is probation. If you just give him this second shot, let's say that the second shot, I don't believe you'll see him again. And I just get that impression just from the support that he has for the family. I mean, you just think about this, Judge, and here's why I be quiet. Think about all of the people who come into your court, right, who don't have that family support and background. He does have that support. And I think that grandmother, and you can look at her, she appears to be a wise lady, years of experience and wisdom. And I think when they have that heart-to-heart grandmother, grandson conversation, if you continue him, I think after that conversation, the chances of him coming back is not going to be good. And I think that conversation is going to take place.
Most people in this room who are defendants don't have that kind of familial support and role modeling at home. He does.
Yes, sir.
Shame on him for having that environment, knowing right from wrong, and still making the wrong choices. Not one wrong choice, choices. You had role modeling at home. That was good. You go against what they were representing. You acted contrary to what their role modeling and examples were. And reminding you, what you tried to tell me a little while ago that I find disturbing is I've got family at home. You had a family at home at midnight when you were almost three times the legal limit of intoxication while you were on probation that forbid that kind of behavior. You should have been at home taking care of the family like you promised you would. And you were put in harm's way because you shot up the town that night and almost killed numerous people by shooting into cars and buildings. Next, what else?
That's all I got.
Yeah, I'll be brief because actually I had an outline of things I want to hit and I ticked them off as you mentioned them. The fact that probation was essentially a gift, you've mentioned that Mr. Adams was admirable in his advocacy in securing this probation for this defendant. I ticked off the fact that you mentioned that your order was a promise that this defendant made. What good is an order if you don't enforce that order, Judge, when it's violated? It's not a suggestion. It's not an invitation. It's not a pretty please. It's an order from the court. This defendant, he violated that order. I ticked off the fact that you mentioned that it's his decisions. It's his decisions that put him before this court. There should be consequences for those decisions. And lastly, Judge, I also ticked off the fact that I was going to remind the court of the underlying facts surrounding the underlying offense, and the fact that he's in a shootout with some other fellow and he's shooting at cars and buildings. And you mentioned that, so that makes my argument very brief, Your Honor. It is admirable that this defendant completed the community service hours he did. It's admirable that he was paying the fees that he paid, but nevertheless, there needs to be accountability, Judge, for violating the court's order. Judge, I go back to my time in the military when there was this phrase that was used called turning sharp corners. For this defendant to be given the gift that you gave him by putting him on probation, he should have known that the corners he turned, he needed to turn sharp corners. And he was cutting corners that night in that Taco Bell parking lot when he was intoxicated, Judge. And the court knows in its common sense that for him to get to that Taco Bell parking lot, he had to drive there, Judge. And in driving there 3 times the legal limit, he endangered the public like he endangered them during the shooting incident, Judge. 5 years is what I'm asking, Judge. I'm asking you to revoke this defendant and assess his punishment at 5 years, which is essentially on the low end or the mid-range of the punishment range in this case, Judge. Mr. Adams made the comment that give him one shot, Judge. When does one shot turn to a second chance, turn to a third chance, turn to a fourth chance? He's making a mockery of this court and this judge's order.
No,
it's his argument, Judge.
No.
It's his argument.
Hold on. Hold on. Let him.
How am I making a mockery?
I didn't say you.
Hold on.
Oh.
Hey, one at a time. Break clean.
I didn't say he was.
Okay.
He gets a chance to be heard, and I'm gonna let you end. What else?
No, my point was the defendant was making a mockery of this of your order.
I thought
that's the way I understood.
Yeah, I thought he was saying I was. Okay, never mind. I take that back. I'm sorry. I apologize for interrupting.
I'm asking you to sentence this judge, sentence this defendant, revoke his probation, reform his judgment, Judge, send him to a prison for the decisions that he made that brought him before you today. And I'm asking you to assess 5 years in TDCJ, Judge.
All right. Anybody else? Anything?
Judge, I'm just asking, and I'm not going. You heard the argument. If not for him, for his mom and his grandmother, just please continue.
And you're right. I feel sorry for them. Why weren't they important to you at midnight when you were intoxicated on probation, when you had everything to lose? And they're but you made a promise to me that you would take care of things. And I stuck my neck out on this because these are 2 crimes of serious violence, which could have resulted in multiple injuries or deaths. On each of these cases in 24 CR 303 and 304, where the defendant was placed on probation, deferred or unadjudicated probation for 10 years for deadly conduct, discharge of firearm, a 3rd-degree felony in each case. In this motion to revoke probation, I find that the defendant has pleaded true to allegations 1 and 4, committing the offense of operating a motor vehicle while intoxicated on or about October 4th, 2025 in Jefferson County, Texas, and being at a location other than his residence at midnight on or about October 4th, 2025. Those are both violations of terms and conditions of his probation. I find that his voluntary and knowingly plea of true are enough in each of these cases to support those findings and allegations by a preponderance of the evidence or greater. I find them to be true, and thus these motions to revoke unadjudicated probation in each of these cases are hereby granted. In each of these cases, the defendant pleaded guilty voluntarily, knowingly, intelligently to the crimes of deadly conduct, discharge of a firearm, a 3rd-degree felony in each of these cases. The defendant was mentally competent to do so. He understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting his guilty plea in each case from State's Exhibit 1 to find him guilty beyond a reasonable doubt. His deferred or unadjudicated probation is hereby revoked. I now find you guilty beyond a reasonable doubt in each of these 3rd-degree felonies, and I am following this agreement. The agreement that was reached is whatever sentence shall not exceed a cap of 5 years. You being found guilty of these third-degree felonies, you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years on each of these cases. These sentences shall run concurrently. Also, these judgments shall reflect affirmative findings that a deadly weapon, namely a firearm, was used in the commission of each of these crimes. Do you understand what has happened now, sir?
Yes.
Your probation is revoked and you are sentenced. And again, this court hates failure. I want to see success. I wish we had 100% rather than 93%. But you understood and appreciated the importance of the seriousness of this violent crime. We all stuck our neck out giving you a second chance. And it wasn't long, a year, and you are failing. And this was fixable. I think you're capable of doing the right thing and doing better. I'm disappointed because I had good ideas that you had fixed these mistakes and you were going to live better with better decisions. But once again, you have family and responsibilities at home at midnight. You're not supposed to be at midnight intoxicated, drunk in a vehicle, sitting around intoxicated while the family is at home and you're on probation. You have to pay a price. Fix this, get out and make a responsible, exemplary life, not only for yourself, but for the children who you are going to be role modeling. You have to set an example and you are able to be better. Do it. All right. That's my wish for you and your family. And again, these sentences shall run concurrently. Anything else?
That's it.
Back on the stage, Judge.
Okay. Thank you, Judge.
Here.
State of Kansas versus David Andrew Salter Jr. It's case number 2024 CR 509. David Salter appears from a Zoom location at the Sedgwick County Jail. James Watts appears as defense counsel. Amber Norris on behalf of the state of Kansas. This is a warrant to show cause matter. Alleging probation violation is the filing officer in this case. Failing to report. There's an accusation that he was in possession of K2, as alleged in a Wichita Police Department report, that he's failed to make monthly payments, and he was unsuccessfully discharged from substance abuse treatment. Those are the allegations. What are your client's intentions regarding these allegations?
Your Honor, I've spoken with Mr. Salter regarding each of those allegations, and I'll just take them one by one, if I may. On
Very
the
well.
first allegation of January 12, he would acknowledge that he failed to report on January 12 and missed that office visit. As to number 2, he's not going to stipulate he was in possession of K2 for obvious reasons. For number 3, he would acknowledge that he failed to make monthly payments and has not paid his case off. As to number 4, my client tells me that he was not unsuccessfully discharged. Rather, he transferred to a different program with permission from his probation officer. That was a Daniel Groots that he was reporting to over in Sedgwick County. And as to the 5th allegation, the addendum, my client would tell the court that he did, in fact, call his probation officer, again, Daniel Groots, and told him about the law enforcement contact that alleged in the ISP agreement, is alleged in the addendum to the warrant. So he would stipulate to the 1st and 3rd of the allegations, would not stipulate as the remainder. I should note one other thing. Mr. Salter reports he is recently remanded to custody on a previous case, which was 23 CR 1504. He's serving or is about to enter a 25-month sentence on that case. I don't know how much of that time he has yet to serve or how much of that is left, how much jail time credit he might have. But he's got a 25-month underlying sentence that he's about to go serve into Department of Corrections. So he would be unable to report for the next foreseeable 2 years, maybe a little more, maybe a little less. Again, it's unknown how much time he might have on that case. We would ask the court that should the court remand them to custody in this case, we would be asking the court for a modified sentence. This case by statute must be consecutive to that Sedgwick County case, 23 CR 1504.
All right, thank you, Mr. Watts. Mr. Ketley, I'm just curious about one of the matters that aren't stipulated to. It should be readily documentable what his status was in treatment. The allegation is he was unsuccessfully discharged. He just says he transferred to another program with permission. Do you have any information that would shed some light on that?
Your Honor, the only thing that I have a discharge summary from Recovery Concepts that said he was unsuccessfully discharged from level 1 outpatient treatment. And I didn't receive any verification from the ISO on whether he's transferred or not.
All right, I don't think I have adequate independent evidence to make a finding as regards to that violation. So Ms. Norris, what is your office's intentions in light of the stipulation to some, but not all, of the allegations?
Your Honor, the non-reporting, I think, is a material violation. So we could proceed with the warrant to show cause. Well, both 1 and 3 are material violations, but 1 is certainly more significant, the failing to report. So I believe that the court could move forward with the warrant to show cause today.
Very well. Mr. Salter.
Sir.
Do you have a right to a due process hearing where the state would have the obligation of proving 1 or more allegations by a preponderance of the evidence? You can challenge the state's evidence with the assistance of your lawyer, present your own evidence, confront the state's witnesses unless good cause was shown. And I need to point out to you that among other lesser remedies that the court could consider, the court could just order outright revocation and have you serve the remaining balance of the original sentence locked up. Do you understand these things?
Yes, sir. Yes, sir.
Do you waive a hearing in the case and agree, essentially enter a no contest statement as regards to failing to report and failing to pay on the case?
I think, yes, sir. I think, yes. To waive it, I think, is that what you said? Yes, sir. Do you say to waive it? I'm sorry.
Yes, waive a hearing. And
Yes, sir.
stipulate you agree that you committed those 2 violations.
Yes, sir. Yeah, yes, sir.
All right.
Yeah,
The
thank
court
you.
finds in this case that Mr. Salter has knowingly waived his right to a hearing and stipulates and agrees that he has committed failure to report and failing to pay violations. The failing to report, I agree with Ms. Norris, is a substantial and material violation of the terms and conditions of the defendant's probation, regardless of his financial status in regards to payment in the case. We'll proceed to disposition at this time. Ms. Norris, you've heard Mr. Watt's presentation and suggestion to the court. What is your position here?
Your Honor, I would be requesting that the court revoke defendant's probation and order him to serve time in the Department of Corrections. This was a departure, so he actually was presumptive prison initially, and the court did depart and allow him to be placed on probation. And this case is consecutive to the Sedgwick County case 23 CR 1504 that he has been revoked on. And Your Honor, I would ask that he serve the balance of the underlying sentence, and it does appear that he's got 9 days of jail time credit, according to jail records. So he does not have significant time served in this particular matter. The underlying sentence ordered in this case is 20 months in the Department of Corrections. And Your Honor, we would ask the court address any attorney and bids fees as part of the disposition.
Thank you. Mr. Watts, do you have additional recommendations for the court regarding an appropriate disposition here?
Well, Your Honor, I would like to be able to tell the court to put him back on probation, but obviously that's not possible given the circumstances. I'm just looking at the journal entry out of Sedgwick County. He has a 25-month sentence there and not significant jail time credit against that 25 months. It looks like basically a couple of months on jail time credit on that case, maybe a little bit less. Judge, we would ask that the court consider modification of this sentence. The two are required to be served consecutively. I know that's not optional for the court to change that consecutive sentencing, but given that he is about to serve 25 months on the Sedgwick County case, and then this case consecutive, I think it would make some sense to reduce this sentence to an amount the court believes is appropriate, and let him resolve both of these cases in the one sentence.
All right, Mr. Ketley, as the representative here from Community Corrections, do you see things differently from the prosecutor's recommendation?
I do not, Your Honor.
All right. Mr. Salter, at this time, the court will address you personally and ask you, do you have any statements that you wish to make in mitigation of punishment or anything further that you would like to present? Mr. Salter?
Yes, sir. Can I read this? Is that okay? Yeah,
You
thank
certainly
you.
may.
Thank you so much. Honorable Ricky, I write here today for the purpose of sentencing above mentioned case. I'm asking for consideration in sentencing to, I ask the court to impose the underlying sentence upon revocation of probation and run the concurrent with 5G23CR150, which I've already sentenced to KDOC for a term of 25 months. I have a transport for KDOC for next week. I'm on my way. I asked Sedgwick County Court to impose my sentence in order. Okay, this is a. Okay, I'm sorry. I'm dealing with both cases in a couple of years, and I finally had to admit that I had a drug problem. My life is out of control. That was a huge step for me to accept the harsh reality that I'm a drug addict. Even though I had to accept I was powerless over the drugs that controlled me for my life. Evidence will show I have been arrested numerous times for drugs for my probation. I have not caught in any cases my issues with further crime, except I'm asking to impose my sentence and I truly get the classes I need, will 100% guarantee that I'm sober. Sorry. And sir, I just got 25 months, man. I'm a drug addict, sir. And the reason why I started using was because I've told you before that my daughter passed away, and I needed to numb that pain. And I didn't need to, but it was what I was doing, and I took it pretty hardly, man. And I'm asking. I mean, you're 25. My wife is 6 months pregnant right now, and I'm asking, man, to just. If you could just please show mercy upon me, sir. I can go through my kids. And I'm sorry. I'm already going to do 2.5 years and I'm going to miss the birth of my son. And I'm asking to have mercy on me, sir. Please. And I just to get the help that I need. And I just want to be sober and have my family. That's all I want. And I'm 42 years old, man, and I'm just tired of this. I'm tired, sir. I just want to do my little time, man, and just go home with my family. Please, just have mercy on me, sir. Okay, thank you.
Right.
I'm sorry, man. Oh, my gosh. I'm sorry. Oh, gosh.
I understand.
Oh, yeah. Thank you.
You're asking for mercy. In other words, what you're asking for is some judicial discretion to not impose as tough of a sanction that could be imposed. I'll just first of all observe, Mr. Salter, that mercy, I think, as you see it, was shown to you at your original sentencing. You were in the B box.
I know.
Your crime was attempted aggravated assault.
I know, man.
We're not talking about a drug crime. We're talking about a crime of violence. Don't talk over me, okay? Because I need to finish this. All right?
Yes, sir.
So, Mr. Salter, you had a chance, but you were unsuccessful because you couldn't complete your probation conditions, not only in this case, but in Sedgwick County case 23 CR 1504. So you've been sent to Department of Corrections custody for 25 months in that case. This court must find, based on current circumstances before the court, that completion of the probation in this case is simply not feasible. He's looking at long-term incarceration in Department of Corrections custody. He cannot report. He cannot complete other probation conditions that were ordered because of his long-term incarceration status that he's facing. Furthermore, I understood your request to include Mr. Salter to run this concurrently with Sedgwick County's case. I think the court is statutorily precluded from doing so or giving you jail time in both cases, jail time credit. So the court at this time, finding that probation is no longer a viable option for this defendant, will order outright probation revocation in Mr. Salter's case and remand him to DOC custody to serve the remaining term in the case. So the only other issue before the court right now in this case, Mr. Salter, is whether the original 20-month sentence will be imposed or a lesser sentence. The court, noting Mr. Watt's advocacy on your behalf, I think he essentially conceded that the situation that you're in, but has asked the court to modify the sentence under KSA 2237-16 to a lesser sentence. Now, Mr. Salter, I'm inclined to do that in this case.
Thank you so much.
But you're going to serve the time imposed here today in the Butler County Court consecutively. That was consistent with the original order, and the court, I don't believe, can even change it. And wouldn't be inclined to change it if the court did have discretion, because you have two separate distinct offenses. You need to do your Sedgwick County time, and then you need to do your Butler time. The court will lower the sentence from 20 to 12 months. 12 months post-release supervision. In this case, no additional fees will be assessed. Anything previously owed in the case is declared by the court to be immediately due, payable, and collectible. But no further fees will be added for this round of proceedings. I don't know if the court's reduced sentence order constitutes mercy in your view. I hope you do see it that way, Mr. Salter. You're going to join your family sooner because of the court's action here today.
Thank you.
I wish you could have successfully completed. That's what the court wanted when it granted the departure in the first place. Unfortunately, you weren't successful, but you'll need to do 12 more months, less any 20% good time credit that you could earn against this sentence. I hope you're able to earn the earliest possible release date.
Thank you.
Mr.
Thank you,
Salter.
sir. Thank you,
So I'm
sir.
going to remand him to custody of an appropriate sheriff's office until his custody can be transferred to the Department of Corrections to serve not only the remaining balance of the Sedgwick County sentence, but the consecutively imposed Butler County sentence of 12 months.
Thank you.
Less any jail time credited in this case. And Ms. Norris, I think you were candid earlier. I think it's only the original 9 days that he'd be entitled to. Is that your assessment?
Yes, Your Honor.
Yes, because I can't grant him dual jail time credit for Sedgwick time. And I do appreciate the cooperation of the Sedgwick County Jail in getting Mr. Salter on the meeting so that we could address this Butler County case. Anything further, Ms. Norris, that the court needs to address here?
No, Your Honor, thank you.
Mr. Watts, anything further that you've thought of that we still might need to address?
I don't believe so, Your Honor. Thank you.
Okay.
All right. Thank you.
That should conclude the Salter matter at this time. And we'll move on to another matter on the docket.
Thank you, sir.
Okay, I think the next case is State of Kansas versus Jacob Denton.
He is in custody, Judge.
Right. And are you Jacob Denton?
Yes, sir, I am.
All right, this is case number is 25 CR 496. If counsel would state their appearances, please.
Jared Ricky on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Jacob Denton. Mr. Denton does appear from the Butler County Detention Facility.
And we are here today for show cause. Are there any announcements on that?
Yes, Your Honor, I have discussed the warrant to show cause with Mr. Denton. I can tell the court that after that discussion, he would at this time waive formal hearing, stipulate that he has violated conditions of his probation.
Is there any agreement with the state?
Judge, I have been in contact with Ms. Norris. Ms. Norris is recommending a 3-day dip and then a 12-month extension. And she is asking that 3-day dip be prospective, meaning from today forward. And that is joined by the defense, Your Honor.
And Mr. Regier, is that your understanding?
That is the state's understanding of the negotiated disposition in this matter, Your Honor.
All right. Mr. Denton, have you heard what the attorneys have told me?
Yes, sir, I have.
Do you understand that by stipulating or agreeing that you violated the terms of your probation, you'd be waiving your right to an evidentiary hearing? That's where the state would have to call witnesses to show by a preponderance of the evidence that you violated the terms of your probation?
Yes, sir, I do.
Has anybody forced or coerced you in some fashion to waive this matter?
No, sir, they have not.
Do you understand that you could be ordered to serve the original sentence as imposed?
Yes, sir, I do.
Very well. I do accept the defendant's stipulation, find that it's knowingly and voluntarily waived with the advice of good counsel. I will hear recommendations at this time, beginning with the state.
Your Honor, the state has nothing further to add beyond the terms previously negotiated and announced on the record.
All right. And Mr. Patterson?
Thank you, Judge. Your Honor, as the court can see, my client is in jail. We believe this is a case where he has approximately 57 days credit for being in jail. And Judge, we have provided the court a copy of a drug and alcohol assessment that he obtained while he was in jail. That is a SAC, Substance Abuse Center of Kansas assessment. It was recommending inpatient treatment, which my client is wanting to do. He's wanting to get that treatment accomplished. I've received information from SAC through Jennifer Romano that they will help him get a bed set up as soon as he is out of jail. So we would ask the court to adopt the recommendation as set forth for the 3-day dip, following which he can then go directly to SAC when he's released and get the inpatient treatment issue resolved, bed date resolved. So we would ask the court to adopt the recommendations.
I believe I believe they have already set a bed date for me on Monday at 9 a.m. as well. So if I could be out by then, that would be fantastic so that I can make that.
All right. Now, I do have that clinical summary report from Substance Abuse Center. It looks like once before, this being in January and February, while he was in jail, there was a recommendation for treatment. He went to that facility, stayed for 2 weeks, and then, by his words, walked out and got high. So he's gone from jail to an inpatient treatment, it sounds like. If I'm stating that wrong, please correct me.
Judge, I believe that is correct. And as you've probably heard, but as I know from talking to other treatment providers, relapses are a real thing. And he wants to get back into it, though, and get this behind him by re-entering treatment. Judge, I think that can only make it better for him in the future if he puts his nose to the grindstone and gets it done this time.
Well, does counsel have any idea how many times he's been ordered to do inpatient treatment?
And Judge, I don't know that, I don't see that in January it was ordered. at least not in this case. So this would be maybe the first one that's ordered.
Okay, Mr. Denton,
Yes, sir.
what's going to be different this time?
Well, this time I've been in jail for 45 days, and so I've gotten detoxed off of it, and I just have a better success plan. I think what happened last time is that I went for 2 weeks and I just got kind of a big head on my shoulders, and I thought, well, I can do this. And I was just, kind of uncomfortable, and I just I went along with what my head was saying, and I know that that wasn't the right direction to go. I also know that this time I have a lot of really good ideas and really good plans set in place that I can get out and I can and really do it. And honestly, I don't necessarily know that inpatient treatment is necessarily the right choice. I think if I went to intensive outpatient, that would also be helpful. And I just plan on staying sober this time, because being sober really, or being not being sober really kind of messed up a lot of really good opportunities that I have, and it kind
Okay,
of
so what is this treatment that's supposed to be set up for Monday? What
believe
sort
it's
of treatment is that?
I believe it's ATC, the Addictions Treatment Center in Pittsburgh, sir.
What type of treatment is that? Inpatient or outpatient?
It's inpatient treatment, sir.
And yet you're telling me you think outpatient's what you need?
Well, only because I just don't know that well, I've been sober for quite a while, and I really need to learn how to.
Okay, it's quite a while since you've been since you were arrested and put in jail.
Yes, sir. And I just feel like I've got to learn how to make good choices in the real world. Because I've done, I've been in jail a few times, and I always, I know I can do it in jail. But then I get out and it's kind of like, oh, I don't know what's going on. And so I think that having the opportunity to attend intensive outpatient and continue on probation and take the suggestions that are offered would be more apt to help my success in the long run.
How many times have you been through treatment?
I've been through
Inpatient or outpatient?
I've been through inpatient 2 times, um, and then this last time, so 2.5 times, sir. It's been, let's see, the last time I went to treatment before this year was, man, it's been probably 12 years or something like that. It's been quite a while.
And Your Honor, if I may, in response to the court's inquiry, there does appear to be a prior felony journal entry out of a 2022 criminal case. It does appear to refer to a sentencing date back in July of 2022, and that same journal entry does appear to refer to ordering the defendant to complete both a drug and alcohol evaluation and a mental health evaluation and following all recommendations.
And I'm not sure how that is associated with the courts, with my client saying it was January of this year.
Well,
or February, I think, but yes.
All right.
Honestly, I just think that given the chance, I know that I can do this, and I just want to be able to come out of jail and be a contributing member of society instead of being kind of a burden on them, because I know it costs a lot of money to have me in jail, and I know it costs a lot of money for me to go to inpatient treatment, and I just kind of want to be able to use what I learn in real life, so that I can have a better hold on success in the future.
All right, Mr. Denton, have you heard the expression, fool me once, shame on you, fool me twice, shame on me?
Yes, sir, I have.
Okay, you say you've learned some things. I've learned a few things as well. And what you seem to have learned or give the appearance of is, doesn't matter what you do, then you're just going to make promises to do better. And then we should let you out of jail. You didn't do it. You didn't appear to do any of the things initially that you were ordered to do. and still haven't. There's a victim that you didn't pay restitution on, and
I don't have any restitution in this case.
let me look at that. Criminal damage to property. Showed a balance of $468. I'm looking at the statement of the probation officer that he stipulated to. Is this defendant has failed to pay any court obligations as ordered. He was ordered to pay $468 and has made no payments to date. Okay, it doesn't say restitution.
And the reason that I hadn't paid any restitution is because I had gone to rehab, and so I couldn't get a job, obviously, and then I left rehab and wasn't able to get any employment as well. So,
well, from looking at your summary and in the history of this case, it doesn't look like you work even when you're out. You go into jail and out of jail with the promises of being sober. And I think it's high time you just served your sentence. So I'm going to deny your request for parole, and you'll get credit for the time you served on this case, but you're revoked. I hope you get the treatments that you need that'll be effective, but you need to understand there's a consequence to these things.
Yes, sir, there is a consequence, and
Yes.
I understand that.
And this matter is adjourned. All right, next matter is.
What's that? Fucking maggot.
I'm not sure I heard what he said. I think I heard. I'm not going to go with it. Ready? Okay, who is it you have there at the detention center?
Judge, this is Mr. Rollins.
Okay, let's take his case up first. State of Kansas versus Artis Rollins III, case number 26 CR 189. Counsel to state their appearances, please.
Chair Revere on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Artis Rollins III, who does appear personally via Zoom audiovisual from the Butler County Detention Facility. Judge, I did meet with Mr. Rollins, and he does appear to request a trial for this matter. So I did file a notice of request for jury trial on his behalf. Judge, there have also been some pro se motions sent to the clerk's office. I don't know if the court has seen those. I can tell the court I've discussed those with my client. I did not intend to argue those for him on his behalf or proceed with those in any way. But I think he also wants to address the court about my services.
All right. And it's a request for jury trial, is that correct?
Yes, Your Honor.
All right. Jen, what's our next jury trial assignment?
Pre-trial is going to be October 26th, with jury trial beginning in person October 28th and 29th.
All right. That'll be our dates. Mr. Rollins, you've got court-appointed counsel. I will hear you, but please understand any statements you make can be used against you if some defendants make admissions or statements against their interest. So I just give you that caution, but I'll hear you.
I would like to fire my lawyer for being ineffective.
You got something to support that, or
I don't even. He hasn't even given me a copy of my discovery. I wrote him a letter 2 weeks ago. He ain't got my letter. My letter actually didn't appear at his office. I'm calling him. He's not answering the phone, so I can talk to him before my court date. No, I can't even get motions filed. I gotta file my own motions.
Okay, where are you residing at this time?
And they got me in I'm in Butler County Jail. They keeping me in segregation because I reported 2 Prius.
You're what?
I said keeping me in seg because I reported 2 Prius. I've been dealing with sexual harassment and dealing with retaliation here, and I didn't.
Are you an inmate at a correctional facility when you're not in the jail here?
And I got a parole violation. I'm here on a parole violation and another charge.
Well, right now I'm going to deny your motion. I would suggest that you try to work with Mr. Patterson. He hasn't been on this case assigned very long, and he has other matters.
I had a whole.
Sir, please do not interrupt.
Well, man, you can't make me keep a lawyer.
Sir,
when I'm telling you,
you need
I'm
to be
fired.
quiet
He's
for a minute.
fired.
You need to stop talking.
And I'm filing a motion for a new counsel, man. You can't force
Okay, Mr.
no fucking lawyer.
Mr.
Fuck me over,
You interrupt
railroad
me
me.
one more? Okay. Mr. Rollins, I find you in direct contempt of court and order you to serve 30 days.
Give a
You
fuck
can be
about
taken
30
back.
days, bitch.
Well, based upon that statement, it's 45 days.
I don't give a fuck about 45 days, bitch.
That will be consecutive in another 30 days.
I'm going back.
Needs to be taken out.
Anyway, big sucker.
Oh, I'm not typing that. That's a lot of days. Oh my God. So he started off with 30 days. He got 45 days. Then the judge said, okay, that 30 and 45 can be consecutive to each other. And I'm going to add 30 days to that. So that's 30 plus 45 is 75. 75 plus 30 is 105? Am I bad at math? Is it 75 complete days? I don't know how to math. Y'all, tomorrow, for the weekend, if you're watching this later, you can look for a thumbnail that says Road Rage and Regret. It's coming in 3 parts. It's a 3-part mini series. Well, it's actually a 3-day court jury trial extravaganza with Judge West in Beaumont, Texas. It is very, very interesting. There is car chasing. You don't get to see any of that, actually, but you get testimony on it. It's car chasing, witnesses of the whole situation, people who recorded it with their cell phone, reported it to the police. There's gunfights with cars moving on the interstate. It's insane. It's mad. And there's lots of interesting legal questions along the way. So I hope you tune in. We're going to start nice and early at 11 a.m. Central Standard Time on Saturday morning. And that'll be part 1. Then come 8 p.m. Saturday night, we'll have part 2. And then Sunday, we will have the final culmination of all the craziness. Ladies and gentlemen, thank you so very much for hanging out with me tonight. Most especially, thank you to Zach, our Florida friend, for his super chat. Uncle Kevin. Uncle Kevin's cool. For the man who always has court cases for his pack, that's me, I think. Charlene, thank you so very much for your super chat. I do appreciate it so very much. It helps out. It helps the channel out tremendously. This little archival project we have going on. Vegas Starlight, I object to Stephen being late. Stephen was actually here earlier and went to do some responsible things and came back when he had an opportunity to come back. We respect Stephen being here whenever he's here. And like I always say, everybody who comes and hangs out with us is like a wizard from Tolkien's realms. They're always present when they are needed. Yeah, I'm talking about Gandalf. I'm a nerd. Thank you so very much, Patrick. Thank you so very much, Car. Carl's Last Order of the Squirrels. I love that name so much. I almost called you Carla there. Mama, thanks for hanging out. We got a long day tomorrow. All of our weekend presentation will be live. No premiere. I hope you join us. As always, I'm your lone wolf Usul. I put these little compilations together. For now, I am out. And remember, only you can take a bite out of crime. Bye! Bueller? Bueller? Hey, why are you still here? We're done. This is over. Go. Go have a tea or something. Or, I don't know. Didn't you hear me say it just a minute ago? Bye!